your go-to resource for U.S. immigration insights. We provide clear immigration news and information. Our platform provides a network of licensed attorneys who can answer your questions and guide you through the process. From visas to green cards, asylums to citizenships, immigrationquestion.com helps you to network with immigration attorneys so that you can move forward with confidence. Sign up today or download the app. Free registration, limited time offer. Stay tuned. We go live in 30 seconds.
Hello, everyone, and welcome to the special edition webinar hosted by immigrationquestion.com, a networking platform and meeting ground where immigrants, families, advocates, and licensed immigration attorneys come together to understand U.S. immigration policies and procedures better. My name is GB Satusa, and I'll be your host for today's important discussion, avoiding costly delays, hidden pitfalls in green card and naturalization applications. Now, for many applicants, the green card and naturalization process may seem straightforward, but even minor errors or overlooked details can lead to delays or additional scrutiny. Missteps such as incomplete documentation or inconsistencies in filings can affect timelines and outcomes. Understanding where mistakes commonly occur and how to avoid them proactively can help applicants move through the process with greater confidence. Now, to help us break this down, we are honored to be joined by David Katona, Esquire, an experienced immigration attorney who assists individuals and families with green card and naturalization applications, helping them meet complex requirements and avoiding common mistakes. Attorney Katona, thank you for joining us today. We're thrilled to have you for this important discussion.
Thank you for having me. I appreciate it.
Now, before we begin, a quick reminder to our audience, immigrationquestion.com is a public educational and networking platform. The information shared today is for general informational purposes only and does not constitute individualized legal advice. If you are joining us on Facebook, YouTube, LinkedIn, or any other platform, welcome. Please subscribe and share this session with anyone who may benefit from understanding how to avoid delays in green card and naturalization applications. So let's dive right in. Attorney Katona, what are the most common reasons green card and naturalization applications get delayed or face additional scrutiny?
Right. Yeah, there are a few reasons why an application may face additional scrutiny or cause delays. Oftentimes, particularly if applicants file on their own, they can sometimes forget to include required initial evidence documentation. Let's say, for example, W-2s. They may fail to include W-2s with their tax returns on an adjustment of status application, which is a green card application. USCIS requires W-2s, and it would, potentially generate an RFE, request for evidence, which would delay the natural sort of processing of the application. There's also certain documentations that are considered required initial evidence. For example, medical exams. The government's gone back and forth on this. Historically, now they actually require a medical exam to be filed with the adjustment application. If you do not file it with the adjustment application, it would result in the rejection of the packet completely. They wouldn't even receipt it in and issue a request for evidence. They would send the whole package back to the applicant. And as anyone who's dealt with immigration knows, they don't send things FedEx overnight. They send things normal mail. They do not, work quickly, particularly to reject things. They have a very busy mail room that's run by contractors. So it might take several weeks, if not, some months to get a rejected packet back, and then you've lost all that time and have to refile and start from scratch. Mm-hmm. So there can be sort of procedural document type hurdles that might result. That also includes, not checking certain required sections of the application. For example, if on the adjustment of status application you fail to disclose, particular financial information in the public charge section, the government may actually reject the entire package back to you. And again, that would take several weeks, if not months.
Yeah.
In terms of additional scrutiny, that could be caused by things like, criminal history, for which the government requires certain documentation, including certificates of disposition. Sometimes they even want to go beyond the disposition of the criminal matter and look at, the underlying criminal complaint, or a plea colloquy, what they call a plea agreement, which is where the court, the defendant pled to certain facts. So they want to see what the underlying facts are, not just conviction. And if you fail to provide that, that would potentially lead to delays, and certainly enhanced scrutiny for criminal matters. Those would be some of the common reasons we'd see.
Yeah. Now, how can errors in forms, missing signatures, or incomplete documentation impact the processing time of applications?
Yeah, as I mentioned, I mean, it can significantly impact processing time, particularly if the packages are rejected. Some people have the belief that if they reject the package, because, when they reject the package, they send it back with a rejection cover letter. And some people think that, hey, if I return it back with that rejection cover letter, maybe they'll treat it as if it were filed on time. That's not the case, unfortunately. They kind of put it back to the beginning of the line, and you sort of start from scratch. So missing, required signatures, key, sections of the application being incomplete, missing required initial evidence, those can result in rejected packages, and again, significant delays. Plus anything that would generate a potential request for evidence, as we talked about before, that could also delay things.
Yeah. Now, Attorney Katona, what types of evidence are most frequently misunderstood or submitted incorrectly, causing delays or requests for evidence, also known as RFEs?
Yeah, so we see oftentimes that particularly with marriage cases, for example, marriage-based green cards, the types of evidence that people submit sometimes are just not quite what the government is looking for. For example, they might just submit a bunch of photographs and maybe a lease document, which of course those are important documents, but the government also wants to see typically commingling of finances, joint assets, joint insurance policies, things like that. So people can sort of stage photos and what have you, and so it's not sufficient proof typically just to submit photos. They do want to see more. So that can be a common misconception. Also some people don't quite understand that there are specific civil documents that the government requires, particularly with birth certificates. There may be many different types of birth certificates that a country issues, but the government typically will only accept, one or certain forms of birth certificates. And the State Department actually has a section of its website where it specifies the types of birth certificates that are accepted. For example, in Canada, you can get a short form and a long form birth certificate. And if you present a short form certificate, people think, oh, it's issued by my government, that should be sufficient, but it's not. They require the long form certificate, which actually lists your parents' information, that which is information that the short form does not have. And so if you do submit the wrong form, or the wrong format of birth certificate, then it would generate at the very least an RFE, request for evidence, which we talked about as causing delays in the process. And sometimes people just can't afford that, particularly if they're waiting for like a work permit to issue because their underlying visa status is expiring and they need that work permit to be able to maintain their employment status. That would be quite costly if they were to, miss a required document, generate that RFE, and then slow down the issuance of the work permit. So civil documents is another one. With citizenship, some people also don't quite understand the travel history piece. This is more informational than document, but it is commonly misunderstood. They think that they don't have to be precise in terms of their travel history in and out of the country, but there's a very specific legal reason that the government asks for entry and exit history with respect to naturalization, and that's because the law has a very specific physical presence requirement that has to be met for citizenship purposes. And so they want to know, the exact precise date that you left, the date that you returned back into the country, what countries you visited. If you don't keep we recommend to our clients keep a real-time travel journal after they get their residency, their green cards, to make the process of applying for citizenship easier. Because if you go back and have to rehash that travel history when you're applying for citizenship, it can be quite frustrating, and you may miss those types of travels, particularly because you cannot retrieve travel history without submitting a request to the government for it, and that can take several months. There is a website where some people can pull their travel history, but not green card holders. It's only people on non-immigrant visas. And so if you don't maintain that real time, it does become a bit frustrating. So those are some examples of things that are misunderstood.
Yeah. Now, are there differences in how USCIS adjudicates applications based on a filing location, case type, or applicant profile that applicants should be aware of?
Yeah, there are definitely differences in terms of field offices. So, immigration offices generally, we're talking about, their service centers, which are, sort of regionally located, and they typically handle different case types. And, they often handle things that don't require an interview with the local office. Okay, so that might include things like visa applications. Um, like work visa applications. It might include things like green card renewals, for example. And different service centers have slightly different dynamics. Some of them receive cases very quickly. Some of them receive cases very slowly. Some of them issue premium processing receipt emails very quickly. Others, you end up getting the physical receipt before you get the emailed receipt from premium processing. So there are, variations also with the local offices where interviews are to be conducted for things like citizenship and green card applications. Those also vary in terms of timing, and also just sort of local office dynamics. For example, some offices might be tougher on particular issues. We often see a situation where people come in on a particular visa where you're not supposed to have the intent to immigrate and apply for residency, and then they later to go apply for a green card. And in some offices, the government doesn't really make an issue of that. But there are certain offices that are much more keyed into that issue, for as an example, and might, question a person's intention at the time of arrival on the visa, where they were not supposed to have the intent to immigrate, like a tourist visa. They might really say, well, what were your intentions when you entered on that tourist visa? Were you really intending to get married and apply for a green card, for example? And they might just be more keyed in on it, and that can vary by field office. So there are definitely variations, both in terms of timing and substance.
Okay. Now, are there any recent USCIS policy changes that applicants should be aware of to avoid missteps?
Yeah. So there are quite a few policy changes. Actually, they happen, almost every day or every other day, seemingly. But with respect to the two case types that we're talking about, why don't we start with adjustments, which is the green card application. With adjustments, big sort of issue that has kind of surfaced is related to public charge and affidavits of support. So there is a section of the Immigration Act which says that people are inadmissible or ineligible for a green card for certain reasons, one of which is if they're likely to become what they call a public charge, which is essentially someone that's going to be dependent on government resources, right? And so The government has kind of gone back and forth over the years on how to assess that. And this administration just recently changed its policy to give adjudications officers a lot more discretion in determining the likelihood that someone will become a public charge. And the statute gives them the discretion to look at various factors, and it includes things like age, health, you know, employment status, highest level of education, specialized skills, so they could look at all these things, and including, a person's financial situation. The adjustment application asks for the person's assets and liabilities and household income, and they can sort of look at all this. And officers are now given a lot more discretion to determine. Whereas previously, for example, under the prior administration, it was a little bit more of a line in the sand type test, where if you earned above a certain income, for example, your sponsor or your petitioner, then even if you were $1 above, or $100,000 above, you'd essentially qualify presumptively, and they wouldn't, typically look too much at some of these other factors, like I mentioned. But this administration tends to be looking more at these other factors. Okay, so it's something that you need to carefully analyze with, your attorney, or educate yourself on before diving into it, just to figure out how you might address it if there are issues that have issues that might trigger flags for them. Another one is sort of discretion. Okay, this administration has also focused heavily on discretion. So it used to be, and historically, it has been that if someone qualifies for adjustment based on let's say, a family petition or an employer petition, then as long as there's no inadmissibility ground that triggers, let's say, significant criminal history, then the person would presumptively, just get approved and qualify for the green card. This administration has made it clear that, well, beyond that, this is a discretionary determination, even if you meet all the statutory eligibility criteria and do not trigger any inadmissibility grounds. We can still, as a matter of discretion, decide to not grant your application if there are negative discretionary reasons. It might be, for example, that someone has worked years without paying their taxes. It might be that someone has is a serial violator of traffic laws, even though it wouldn't trigger a criminal ground of admissibility. If they have like 10, 15, 20, 30 parking tickets or speeding tickets, they might say, well, that indicates that you're sort of maybe not that this doesn't warrant a favorable discretionary approval. And so they look at some of these factors that they haven't traditionally looked at. That is quite important. So I'd say on the adjustment, those are the two probably bigger issues that jump out at me. On the citizenship side of things, the government has also now sort of changed its position on good moral character. So good moral character has always been a requirement for citizenship. The government specifically looks back the last 5-year window before you file. In some cases 3 years, but either 3 or 5 years, and you essentially have to show that you've been a person of good moral character. And historically, as long as there was no negative factors in your case, the government again would presume that you met good moral character, the good moral character showing requirement. This administration has sort of flipped the script and said, well, wait a minute, we're actually going to make you affirmatively prove that you're a person of good moral character, and so you need to go out and get character letters, character reference letters, other proof that you're a contributing member to society. Might be, as an example, that you're gainfully employed and filing your taxes, or that your kids are performing well in school, which indicates that you're a good parent doing your job as a parent, that you're involved in the community. And so they put the onus on the applicant to affirmatively present evidence to show good moral character. And if you do not, then at least their position is that they can do these, what they call neighborhood investigations, which is, theoretically where they send out immigration agents to your neighborhood and question your neighbors, your employer. Is this person, a good person of good moral character? Is this person deserving of citizenship? So the administration has taken a much more solid, firm stance on this, that citizenship is, a privilege, and that people only who are actually affirmatively showing that they're deserving and good people will qualify. So that's kind of a big one that jumps out for citizenship.
Yeah. Now, what role does legal representation play in anticipating and preventing delays in application processing?
Yeah, I think it does play an important role for sure. I mean, as you're sort of getting a sense here, there's a lot of potential missteps that can happen along the way in terms of, how you fill out forms. A lot of people think the forms are just, boxes that you either check or don't, and information that you provide. But a lot of information on the forms are tied to specific legal definitions, and those legal definitions might have legal consequences. And if you don't have an understanding of the legal sort of background, then you may not, know how to disclose a question. I mean, there are questions on an application that sometimes in our office we debate how's the best way to answer it, given how the question is worded and given the legal background, and it's not clear. I mean, if it gives a law office pause as to how to answer a question, certainly someone who doesn't have legal training or an understanding of the immigration statute, would probably not be equipped to answer those in many cases. So, helping with, things that are seemingly straightforward, but do have some, important legal context, making sure that, certain documents are included, anticipating issues, also being aware of trends in terms of, what are new policies that might have just triggered a week ago, 2 weeks ago, and they may not be yet, fully in the public realm or, clearly visible out in the instructions to the application. That person might miss something, right? It might be a change of filing location, for example, and they might have looked at the filing location 2 weeks ago when they prepared the application, but the filing location changed yesterday, and now they file it to the wrong service center or wrong address, and the package ends up getting sent back, and you lose, several weeks, if not months, to get that package back. So, attorneys obviously should be up to date on real-time changes in policy and procedure, and case law evolves as well. Birthright citizenship is a perfect example. That's is something that might change, hopefully not, but could theoretically change, and that could change one day to the next. So being aware of those issues, I think, is important as well, and that's what attorneys can provide.
Now, Tony, looking ahead, what practical strategies should applicants implement to increase chances for positive outcomes for the green card and naturalization application?
Yeah, I mean, I think that the practical strategy would be to, align yourself with a good law office or attorney, to, really sort of map out and understand the strategy. One thing that, I feel strongly is that an attorney should help help educate applicants about the process. Oftentimes there are decisions to be made in the process, and attorneys shouldn't, in my opinion, necessarily be making those decisions for clients, because the clients are the ones that live with the consequences of those. Rather, the attorneys should be educating clients about what this means. If this, we take this path, here are the consequences and the timing, and you can't travel, for example. Whereas if we go this alternative route, here are the consequences of that route, and what have you. Oftentimes we hear from clients that come from other law offices, oh, this attorney told me to do that, but they didn't explain why, and ends up maybe sometimes causing an issue. Sometimes it doesn't, but sometimes it can, and had the client been educated and, taken ownership of that decision, then they would be sort of better aligned on the strategy. I think, partnering with somebody or really understanding, the process and coming up with a sort of a holistic strategy, timing wise, substantively and everything is very important these days. Just because, again, there's a lot of moving parts. And by the way, there's issues that one can anticipate. If an attorney is aware of proposed regulation that might change something midstream, educating the client about, well, how this might change, 2 months down the line, So if we don't file before this change, then it's going to be a whole different ballgame. That's important too.
Yeah.
That would be sort of the takeaway.
Thank you so much, Attorney, for those valuable insights. Very eye-opening. Truly an interesting session so far. Now, for everyone watching, this discussion about avoiding delays is not meant to cause any concern, but to encourage preparation and attention to detail. Accurate documentation and awareness of current requirements can make a meaningful difference in how efficiently a case is processed. If this is your first time joining us, welcome. ImmigrationQuestion.com is a networking platform where users can ask immigration-related questions at no cost and engage with participating attorneys. We're also proud to share that ImmigrationQuestion.com is BBB accredited and ISO certified. This is reflecting our commitment to transparency, accountability, community education, and security. Now, Attorney Katona, based on your experience, how does ImmigrationQuestion.com help immigrants and immigration attorneys such as yourself?
Yeah, ImmigrationQuestion.com has a lot of helpful information, that I think you guys do a great job filtering as well. I mean, anyone can sort of chat GPT or, research things on their own. However, a lot of times there are sort of nuances in applications in practice, that I think shed an important light on some issues that you cannot extract just on your own. And so having these types of sessions with attorneys, to help filter information, also identify things that may not be in the public realm just yet, but are sort of on the horizon, is also important. So having that sort of practical insight from practitioners, I think, is really helpful thing that the platform does. Commonly asked questions, I think is also another one. It helps just clients filter a lot of information out there. There is a lot of disinformation out there, and so helping cut, straight to the heart of the matter, I think is really helpful. So those are some of the ways I think the platform is really, really helpful.
Thank you so much, Attorney. Now, before we move into our live Q&A, let's tackle this important question. What is one common misconception that applicants have about the causes of delays in green card and naturalization applications that you believe should be clarified?
Sorry, you got cut off at the end there. Can you say the last part?
All right. So, what is one common misconception that you believe or applicants have about the causes of delays in green card and naturalization applications that you believe should be clarified?
Yeah, I think the misconception is that it is an easy process, that it's just about filling out a bunch of forms. Why do I need, help on this? Why do I need to spend time understanding it? I'll give you a very real world example. In the employment-based adjustment of status context, when someone is applying for a green card through employment, the law is quite unforgiving when there is any sort of unauthorized employment, failure to maintain status. That can actually destroy one's eligibility to qualify for adjustment of status. And so some people, carelessly fill out applications without correlating back to applications that were previously filed by their employers, for example. There might be a mismatch in job titles or job duties, and that could trigger serious flags about whether somebody who was supposed to be doing job A, because let's say you had a TN visa as a management consultant, and you say you were doing a completely different job, and that could raise questions about whether you were properly maintaining your status. And if you were not, that would actually result in the denial of your entire application. So being, I think, aware of that is a pretty important one, that this is not just about filling out forms. As I mentioned earlier, all the information and the questions that are requested in these forms are tied to very specific legal requirements, elements of the law, definitions, and having an understanding of that can be very, very important.
Yeah. If you've just joined us, we've been speaking with Attorney David Katona on avoiding costly delays hidden pitfalls in green card and naturalization applications. We are now moving into our live Q&A session. This is your opportunity to ask general questions and hear educational insight from a licensed immigration attorney. Please drop the questions in the chat or call us live at 516-703-3483 and we'll take as many as time permits. All right, the first question is it normal for my green card case to have taken 6 years now?
Well, tough to say out of context. I mean, I'd say most green card cases don't take 6 years, but it depends also on various factors. I mean, if you're talking about, let's say, a perm-based green card application and you're an Indian-born individual, that can take decades, you know. So I don't know at what, phase of the process you're in, whether you've actually filed your adjustment, whether there's, any visa retrogression issues. Visa retrogression meaning, the government has a quota on the number of green cards that they can issue per year. And so they sort of meter the issuance of those green cards. And people obviously, who file in particular categories have a longer wait time in order to have access to what they call an immigrant visa number to be able to get their green card. So there are situations where people are waiting this long, if not longer, due to things like visa retrogression and potentially other factors. So hard to say. I would say, it is a bit of a long wait. So if you haven't spoken to an attorney, I would recommend it, but there could be good reason for it.
Yeah. All right. What happens if I fail the citizenship interview or test?
So if you fail the test, meaning the English language or the civics and history portion of the exam, then they do allow you to retake it. Usually, 2-3 months later, they'll call you back and give you another chance to take the test. If you fail a second time, they would deny the application and you'd have to reapply. So I presume that's the question. I mean, there's other reasons you might fail an interview. For example, if they think you're not a person of good moral character, they think you didn't correctly obtain your green card, for example, you spent too much time out of the US, those types of things can also lead to, denied green card. But if the question relates to the actual test, then they do give you a second chance to take that test.
Please, what mistakes delay citizenship applications the most?
I don't know if I can say what delays it the most. I mean, I can say common reasons for delay, and again, that could be things that result in requests for additional documents. For example, not providing disposition letters. Disposition letters are basically letters you get from the court when you've had a criminal conviction that tells the immigration authorities what happened in your case, right? Also failing to disclose important information like alternative names, AKAs, also known as names, aliases. If you don't disclose those things, sometimes the government has a reason, wonders why, and they might do enhanced sort of screening, or if your name happens to relate to somebody on a watch list, then that could obviously trigger delays because they might have to do government name background checks. If you don't disclose travel history, the government has its own ways to obviously pull your travel history. They're not going to rely 100% on you. But if they think that the failure to disclose travel was because you were trying to, hide or obscure extended travel abroad, that could be a significant issue that could cause delays as they look into your travel history. So those would be some of the common reasons. There could be others. It could be, whether like if someone got their green card through marriage, and divorced shortly after. There can be situations where they even refer cases to Homeland Security investigations, which is the investigatory arm of immigration, to see if there's potential marriage fraud that took place, even if they didn't identify it back at the initial green card stage. So those types of things can cause delays as well.
Right. Now, recent reports indicate that the Supreme Court has signaled doubts over a proposed birthright citizenship plan, contributing to ongoing discussions around immigration policy and constitutional interpretation. Attorney Katona, when expectant immigrant parents hear about developments like this, should they be concerned about their children's citizenship status now, or is it too early to worry about?
I think it's a little bit too early to worry about that now. Yeah. Yeah, and I mean, as you said, I mean, there was the way the oral arguments went, there was quite a bit of skepticism among the justices about how this would square with the Constitution and prior Supreme Court history and opinions. So yeah, I think it would be a little too early to worry about it. Obviously, if there's a decision that goes contrary to what everyone's expecting, then that would be a time to worry. Even then, Congress could step in and sort of clarify, pass laws or what have you. But yeah, I'd say it's a little bit too early to worry at this point.
All right. Thank you to everyone who joined this special edition webinar. And thank you, Attorney Katona, for sharing your knowledge and practical guidance with us today.
My pleasure. Thanks for having me.
To everyone else, you can visit immigrationquestion.com to ask immigration-related questions, stay informed about policy updates, and register for upcoming live events. If you did miss any part of this important discussion, the replay will be available very soon on Spotify. Just search Borderless Talk by immigrationquestion.com. Until then, we do look forward to seeing you on Friday at our next live session. Until then, stay informed, stay prepared, and stay connected. Bye-bye.